beautiful cadence, unquote, of Dr. Higgins's voice. I expect no such emotion this morning from Justice Gleeson. Long regarded as the hard man of the New South Wales Court of Appeal. That is, of course, a term of affection. It is not a reference to any lack of empathy or compassion on his part, but to his rigorous and principled approach to the discharge of his judicial responsibilities. In his court and in his judgments, no hard case was allowed to make bad law, no corner was cut, no difficult issue of law or fact was glossed over, nor was any counsel, junior or senior, permitted to obfuscate or engage in bluff when confronted with a difficulty in their case. Now, I may or may not be drawing on personal recollection in making that observation. Justice Gleeson would politely but firmly direct counsel to a particular issue and clearly ask for a response to a simply worded but invariably centrally important question. Counsel were generally given 2 opportunities to respond. Justice Gleeson took a similar business-like approach to unrepresented litigants whom he treated firmly but always fairly and with respect. The difficulties in keeping some such litigants to the point and foreclosing repetition can tax judicial patience from time to time. One colleague has referred to feeling a palpable sense of relief when the judge was presiding. The litigant was moved along with a firm hand without a trace of impatience and seemed to realise the judge was helping, not shutting them down. Most responded well to such direction and proceedings moved ahead. In his more than 12 years as a Justice of the Supreme Court and as a Judge of Appeal, and over 1,000 judgments later, His Honour has earned great respect from both his peers and the profession, many of whom have gathered here this morning to honour that contribution and perhaps to ascertain his availability for future advice. This is hardly surprising. He came to the court in April 2013 with an outstanding reputation, especially in the areas of corporations, equity, insolvency, and commercial matters more generally. That personal reputation has only been further enhanced, as has this court's commercial reputation during and by reason of his time on the bench. Part of his commercial acumen may be attributed to his boyhood excitement on being introduced to double-entry bookkeeping. He remains a fun guy. Sitting with His Honour for the last 6.5 years has, for me, been a privilege. He has brought to all his work not only his strong intellect and work ethic, but a deep knowledge of legal and commercial matters, thorough and early preparation which allows the court to maximise the benefit of oral engagement during the hearing and also facilitates the expedition with which this court invariably delivers its judgments. Some cases, of course, take longer than others to deliver, usually because of the number and complexity of issues, a multiplicity of parties, and the length of the underlying trial. The fact that Justice Gleeson has sat on many multi-day appeals is no coincidence, demanding acute concentration, the ability to master detail, and a laser-like focus. Such appeals require extensive preparation and pre-reading, as trials which may have taken many weeks or even months are condensed into an appellate hearing of a matter of days, and then there is the writing involved. His judgments are always models of clarity built on a superstructure of systematic logic. Some of the lengthy and difficult multi-day appeals in which His Honour has participated include Zay 2 and Low, a 6-day appeal in which His Honour wrote the leading judgment on important and difficult issues such as limitation by analogy and equity, tracing and the effect of indefeasibility on personal claims in equity. The Sydney Local Health District case in which I sat with His Honour, a 5-day appeal following an extremely lengthy and protracted trial involving difficult questions of mean profits, taxation and accounting. Clancy and Bird, another 5-day appeal, including multiple allegations of sexual assault in a childcare centre. Casaniti and Ball, in which some 15 appeals were heard together, arising from the principal judgment of some 2,784 paragraphs. With a supplementary judgment involving claims of breach of fiduciary and statutory duty, accessorial liability and equity, and under statute for knowing assistance and knowing involvement in those breaches of duty. Another one 2 years ago, Anderson and Canaccord, another 8-day hearing appeal in the Court of Appeal. An 8-day appeal is a massive massive undertaking. There are countless other judgments of His Honour in the Court of Appeal which are of great significance and which span the whole gamut of the court's work, including his last decision delivered yesterday in Metal Manufactures and Westrack, which involves a detailed consideration of the personal property securities legislation, which may be His Honour's favourite piece of literature. Moreover, as public lawyers have pointed out, without extensive prejudicial exposure to public law or to crime, His Honour immersed himself in novel areas and wrote with the assurance of one enjoying long experience. Areas in which His Honour has given leading decisions include, of course, equity, breach of fiduciary duties, estoppel, subrogation, equitable remedies, trusts, in tort, in corporations, in defamation, administrative law, restraint of trade cases, a number of leading decisions there, tax and state revenue, and child welfare. Some of His Honour's judgments have been actively debated, including internationally. A recent example, Zhao and BCEG International, addressing inter alia split elections and equity, has been the subject of learned articles in the University of New South Wales Law Journal, the Commercial Law Quarterly, and was recently discussed in the Cambridge Law Journal. Justice Gleeson has also participated in over 150 decisions of the Court of Criminal Appeal, and there are a number of leading decisions there which will be recorded, but one which I recall well, Pratton, involved offences of dishonestly obtaining a financial advantage by deception, lodging tax returns, not disclosing all assessable income, and His Honour's commercial acumen was in that case able to be combined with the criminal context of those proceedings. Justice Gleeson has been a valued mentor to many judges of the court during his time, not only in the Court of Appeal, but especially in the Equity Division, and then especially in matters involving schemes, insolvency, fiduciary duty and corpus law, where his knowledge and expertise has been much in demand. In that context, like many Court of Appeal judges, he has also sat extensively at first instance. He has delivered 124 judgments, mainly in the corporations list over his time, sitting at first instance, as I say, dealing with the whole range of corporations law, the menu, special purpose liquidators, special purpose receivers, windings up, appointment, removal and remuneration of liquidators, liquidators examinations, distributions on insolvency, derivative actions, and many matters concerned with practice and procedure in corporations, list matters including corporate reinstatement, scheme meetings, statutory demands, and offsetting claims. In the corporations list, expedition in the resolution of issues is frequently demanded and always delivered, and he made a very significant contribution over the years in adding his, not only his energy and dealing with those cases, but also, as I say, acting as a mentor to more junior judges. He's been an enormous and much valued colleague to me. As an extremely senior judge in the court, I've regularly sought his counsel on difficult issues confronting the court and run ideas of varying merit past him. He has pointed out that the merit of my ideas varied. But his advice has always been shrewd, astute and concise. He generally does not do small talk, but is always happy to discuss matters of state, national or international politics, or rugby union. As a former first-grade rugby union player, his knowledge of the configuration of the dressing shed at Drummoyne Oval and lines of sight into that dressing shed was especially invaluable during the hearing of the defamation case involving the West Indian cricketer Chris Gale. You will have to read the judgment to fully understand what I mean. As an intellectual leader of the court, His Honour has also delivered a number of learned papers to the profession, one being his recent presentation on Kramer and Stone. And His Honour, very pleased to say this and in a sense to announce it, His Honour will deliver this year's Bathurst lecture focusing on legal issues surrounding cryptocurrency, expanding on his initial exploration of that topic at a Hong Kong conference in March last year as part of the New South Wales, Singapore, Hong Kong Commercial Judges Biennial Colloquium. A very, very important topic, and I'm confident that that will be a significant lecture, heavily attended not only by the profession but by senior members of the commercial community. So on behalf of the judges of the court, I thank Justice Gleeson for his very substantial contribution to the life and work of the court and for his friendship, and wish him a healthy and happy retirement. I suspect it will be a busy one. Thank you. Dr. Higgins, do you move?
May it please the court. I too acknowledge the Gadigal of the Eora Nation. I give my respect to their elders past and present, and extend that respect to all First Nations persons present today. Chief Justice Bell, it is an honour to speak today on behalf of the New South Wales Bar Association. Justice Gleeson, the school you attended, St Patrick's College, Strathfield, runs a programme named after your honour, the F. Gleeson Gifted Education Programme. The pamphlet that describes that programme identifies, and I quote, the 4 key parts of Gleeson as being extension, enrichment, differentiation, and acceleration. Let us see then, as your honour retires from a distinguished 45-year career in the law, how you have measured up against each part. Extension is a phenomenon most directly experienced by those who have worked with or appeared before your honour. Your honour is succinct and efficient to an almost military degree. You expect proper preparation, diligence, and candour in all personal and professional interactions. Your honour graduated from Sydney University in economics in 1978 and in law with honours in 1980. You commenced as a solicitor at Freehill, Hollingdale and Page that year and became a partner 5 years later at the age of 27. That rapid elevation was driven by your remarkable work ethic, legal aptitude, and fierce interpersonal style. Consistent with this, your nickname at Freehills was the Boot. A similar kind of extension was experienced by those whom your honour cross-examined while at the bar. The decision of the full federal court in De Bortoli Wines Proprietary Limited and HIH Insurance Limited, where your honour led Justice Williams, is substantially occupied by extracts from your honour's cross-examination at first instance. That includes the following discussion by the court. Mr. De Bortoli went on to insist that during July 2000, the interim results of HIH, dated March 2000, gave me some comfort. After several further questions, the following exchange took place. Mr. Gleeson, so there was nothing positive in this report, was there? Mr. De Bortoli, well, I wouldn't say it's negative either. Mr. Gleeson, okay, so you don't read high risk as negative and recommendation downgrade as negative. Mr. De Bortoli did not succeed on his appeal. Your honour has also been innately driven to self-extension. Your honour was called to the bar in 1991. From that point on, you practiced in corporations and insolvency, equity and commercial law, insurance, and professional liability. In several of those fields, your honour was peerless. But your honour was never avaricious for new briefs. You wanted at all times to perform at the highest level in the briefs you already held. That produced among solicitors who knew your honour well a Fabian hack. The hack was this. When calling with a new brief, do not begin the call with, "Hi, I was wondering whether you have capacity to take a new brief." That would elicit an almost instantaneous no. Instead, immediately state the legal problem the case threw up. That would provoke your honour's interest and compel you to find an answer. It would ultimately elicit an excited yes. The notion of enrichment may appear to jar when one knows that your honour once went by the name the Boot, but that is to overlook a profound aspect of your honour's nature. In 2018, while in the Court of Appeal, your honour served as patron of New South Wales Young Lawyers. In a speech to young lawyers that year, you said this: "We have a collective responsibility to express in a meaningful way care for the well-being of others with whom we work and interact." That was a model of care your honour instantiated. In every role your honour has occupied, while you have been notoriously busy and intolerant of all forms of surplusage, you have found time to attend to important issues in your friends' and colleagues' lives. If something mattered, your honour prioritised it. That solicitousness took many forms. On one occasion, a partner from a large law firm mentioned to your honour that a reader in your honour's chambers had started dating a senior associate in that firm. The partner asked your honour, perhaps on reflection and jest, to ensure that the barrister behaved himself. Your honour then, at roughly 3-month intervals, went into that barrister's chambers to confirm whether he was in fact behaving himself. At your swearing-in ceremony on the 29th of April 2013, Your Honour noted the advice given to you by each of your three children on that occasion not to try to be funny. But in truth, Your Honour is not without colour and humour. When the Court of Appeal recently held sittings in the City of Orange, a member of the court suggested that each judge should wear something orange to celebrate the occasion. Your Honour showed adequate daring by wearing orange socks. Another member of the court, who can remain nameless but whose identity will not thereby be protected, wore orange stilettos. Differentiation is a pressing issue for a legal Gleeson. There is a gallery of brilliant Gleesons in the law, but Your Honour has found ways to differentiate yourself. One means of differentiation has been your mellifluous baritone, if not bass, voice, which rivals that of even Stephen Finch FC. That for many years appeared to have a mildly hypnotic effect on judge and client alike. That effect changed when Your Honour was appointed to the bench. Someone speaking that deeply from up on high, asking whether you've advanced your best point, can be a little disconcerting. The baritone did not, however, assist Your Honour in pronouncing words in foreign languages. On the bench, Your Honour routinely resorted to renaming authorities along the lines of that ship case in lieu of some confounding Spanish or French name, but counsel invariably knew what Your Honour meant. Another means of differentiation has been your distinctive stride, which appears to signal that Your Honour is continually competing in an Olympic speed walking event. Your Honour has also demonstrated perspicacious levels of insight. In 2018, Your Honour said this: "Lawyers tend to have unique, somewhat eccentric personality traits. A few of the eccentric lawyers who can't get on with each other tend to become barristers. Those barristers that can't get on with each other become judges." That observation involves characteristic understatement. Your Honour was a founding member of Banco Chambers in 2005, the year that you took silk. You were a hugely influential and valued member of that set. You there built lasting intergenerational bonds with numerous barristers. As remarked by the Chief Justice, on the bench you have continued to be an intellectual leader and have provided an abiding example for barristers practicing in this state of the virtues of honesty, precision and brevity. Acceleration brings us finally and ineluctably to rugby union. Rugby has been an important part of Your Honour's life since your early days at St Patrick's. You were a legendary number 8 breakaway, tearing across the grass in your white and black jersey. It is perhaps unsurprising that Your Honour was drawn to a life at the bar, given it allowed you to keep wearing the black and white strip. Your Honour played first grade for Western Suburbs, now West Harbour. Wests has a proud history, having been founded in 1900 and producing no fewer than 48 wallabies. Unfortunately, Your Honour is not one of them. Nevertheless, Your Honour is reported to have played every game with a level of artistic violence and total disregard for the rules of the game that was expected of a first grade forward in that era of the gentleman's game. Nor did the blows end at the school gate. One barrister, now a silk, tells of Your Honour bringing him into a matter when he was a reader. The first conference was held first thing on a Monday morning. The junior, already a tad trepidatious, sat down opposite Your Honour and saw that your right eye was a swollen conflagration of purple-yellow bloodshot horror. Your Honour saw him looking and simply said, "Rugby, eye gouge." Your Honour paused a beat and then, well schooled in the rugby union canon, said, "The other guy had it much worse." Justice Gleeson, having established, perhaps unsurprisingly, that Your Honour satisfies the 4 parts of Gleeson, can I end where I began? The F. Gleeson programme pamphlet to which I referred earlier opens with a quote from G. Key Nelson, which is this: "Successful people are not gifted. They just work hard, then succeed on purpose." That quote both perfectly reflects Your Honour's modesty and imperfectly reflects Your Honour's native ability. Your Honour has been a prodigious solicitor, a superb barrister, and a distinguished judge. You have contributed profoundly, if with an insistent understatement, to the legal life of this state and nation, including through the diverse judgments summarised by the Chief Justice this morning. Time and space now unfurl before Your Honour in a way that they have not for some decades. How they will be used will be revealed soon enough. There are many books to read and fast walks to be had. There is time to spend with your wife Sue and your children Tom, Kate and Sarah. Come 2027, when the Men's Rugby Union World Cup is hosted by Australia, We need not speculate as to how Your Honour will be occupied. Justice Gleeson, the barristers of New South Wales thank you for your contribution to the administration of justice. We will miss you, but we wish you contentment in everything you now choose to do. May it please the Court.
Ms Ball, President of the Law Society of New South Wales.
May it please the Court. I too acknowledge the Gadigal of the Eora Nation, the traditional owners of the land on which this Court stands, and I pay my respects to the elders past and present. I acknowledge and extend my respects to all Aboriginal and Torres Strait Islander peoples who are with us today. Before I go further, may I say that I appreciate Your Honour is here because you want to thank people, and that is possibly it. Otherwise, I believe there was something approaching apprehension in being the centre of attention today. For one small moment, I will alleviate that, as I would like to acknowledge Your Honour's family, friends and colleagues with us here today, as well as the honourable members of numerous courts, court staff, including Your Honour's associates, and all those who have been close to Your Honour over your 12 years as Justice of the Supreme Court of New South Wales and Court of Appeal, especially those who have supported and buoyed Your Honour and variously contributed to Your Honour's success. I'm afraid that will be your only reprieve from the spotlight, Your Honour. For today's celebration, colleagues have recalled many things. Some stretched far back, all the way to 6:30am and seeing Your Honour at Bean Bar Cafe, for example. Others went even further. One excellent lawyer and lifelong friend recalled seeing your high school mathematics teacher, Brother Killian, write a complex quadratic equation on the board that no one got. And Brother Killian simply saying, "Tell them, Fabian." He also said that on the point of cricket, while you and your brother Justin and John Fernan were in the starting lineup at university, you didn't win any matches, but you won every argument. It was a sign of things to come. Despite this and an amazing legal and commercial sense, Your Honour has been known as someone who would always talk to everyone, to waiters, baristas, or given your proclivity for early starts, the milk delivery person. Someone who's interested in society as a whole and people from all walks of life. It was said that Your Honour has brought all of this to your judgments, everything that makes up your large intellectual curiosity. I know that on this bench, Your Honour was also acutely aware of the reality of how law affects the lives of those appearing before you, from commercial cases with corporations pitted against government regulators or investigatory bodies or liquidators or other corporations, to the large number of cases in the Court of Appeal with matters affecting the daily lives of people from huge range of backgrounds, and of course in many criminal matters of the most serious degree. Your Honour's decisions have had real consequences beyond the technicalities of law, and it has never escaped you that for half of those appearing before you, it would not go their way. Nevertheless, your own rigorous high standards in knowing the law and applying it to the facts, alongside those of your brother and sister judges of this outstanding Court of Appeal of New South Wales, have been consistently met. But despite achieving within this environment as far as my research could ascertain, Your Honour is not quite near the mandatory retirement age. And while Your Honour has expressed the view that this is a very talented group of judges from diverse backgrounds, both on the Court of Appeal and across the divisions, after 12 years you would like your Sundays back. When asked how your wife, Sue Gleeson, views this retirement, you said, and I quote, "most favourably." And as an aside, publicly noted 12 years ago, Your Honour recently reconfirmed to my team that Sue remains the funny one in your relationship. Disliking self-congratulation, Your Honour was careful when asked what you have been adept at on the bench. Your Honour merely said, "being able to turn my mind to different subject matters across a whole range of appeals in cases," and then with more loquacity, if such a term could be stretched to Your Honour, added, Put it this way, some of it's a bit like a coal miner exploring a mine. But where Your Honour may be uncomfortable with the focus being on your abilities, especially in your own eyes, may I say that the legal profession was very forthcoming with their thoughts. One lawyer who has known Your Honour for a very long time and appeared before Your Honour said it was clear you have good values, apart from on the rugby field where white line fever had historically turned Your Honour from a mild-mannered person into a wild man. He noted that appearing before Your Honour could bring forth some of these impressive rugby skills, testing but fair. Putting forward an argument without merit would be destroyed very promptly, but that Your Honour had compassion and a great sense of social justice. This has been taken onto the bench, subject, of course, to the application of law. From other members of the bar, there were various remarks about a rumour that whilst playing in first grade rugby many, many years ago, Your Honour had possibly, so the rumour goes, been sent off for, let's say, inopportune use of feet. One practitioner said they could see in your eyes when faced with a hard question from the bench the possibility that the rumour could be true. But even after 12 years, barristers still remarked that it was an incredible feat that you had been persuaded to join the bench given your practice at the bar. It was a reputation which over your time on the bench made counsel and solicitors alike fear the common, invariably correct words, "Isn't this the issue?" And what followed was always the issue. But they noted with real enthusiasm that what would follow such a moment was an opportunity for engaging genuine advocacy. The possibility of offering arguments that truly went to the heart of the matter and being heard with absolute focus. And whilst someone suggested with a smile that all counsel were relatively, equally, intellectually terrified, they also suggested Your Honour may have helped in bringing more women to appear at the bar table. Allow me to elaborate. One senior, brilliant barrister easily recalled in the 1980s and seeing the then second youngest partner ever at Freehill, Hollingdale and Page, this iconic, amazing litigation partner, Your Honour, who, despite all the legal ability and over 30 years later, was ultimately noted as very handsome. I appreciate this may be turning Your Honour's dislike of being the centre of attention up to the power of 10. And so I also say lawyers recalled back in private practice sending Your Honour long, detailed emails and simply getting a response, yes. More seriously, Your Honour's mentoring ability ran easily from being a lawyer into your elevation into a judge and has been warmly remembered by colleagues. Your collegiate and helpful nature for those new to the bench was as appreciated as it had been by those at the bar. Efficiency with language and reasoning has also been reflected in your judgments and noted by many lawyers. I know Your Honour has spent a great deal of effort construing every one of these. It has not been a weight borne lightly, and even if the result seems effortlessly reasoned and to the point. I also know Your Honour has spent much of your own time thinking about these in the wide range of work, from conviction appeals to child sex offences, to, say, security claims in insolvency disputes. Swimming has been a refuge for your mind that has helped unwind the points that you have occasionally been caught on. Your mantra was always quick, quick, wrong. And stopping to consider things deeply has been a hallmark of your judgment. I'm also aware that whilst you have enjoyed writing judgments, their absence will probably not keep you awake at night. Very often in discussing law as a concept, we focus totally on the institutional side of things and forget to mention the people that are there, that make it real. Throughout Your Honour's career then, as a solicitor, at the bar and on the bench, Your Honour has been very well liked. Someone who has given great service to the people of New South Wales, a wonderful example of someone who has given so much to the job and is still in the prime of their life. I have no doubt that your sound commercial sense, realistic, worldly, and deep legal acumen will take you extremely far in whatever endeavours Your Honour turns your mind to next. It has been an absolute pleasure to see Your Honour on this bench. I really mean that. And I hope that Your Honour has many enjoyable deeply deserve some life, your children and your grandchildren. On behalf of over 43,000 solicitors in New South Wales, thank you, Your Honour, for your contribution to this court, and congratulations on what has been a highly regarded judicial career. As the court pleases.
Thank you. Chief Justice, judges of the court, distinguished guests, including judges of other courts and retired judges, members of the legal profession, family and friends. Thank you for your attendance today at this farewell ceremony. In doing so, you honour the court and me. When I look across to the right, I'm buoyed by the generosity of spirit shown by the attendance of judges and retired judges of other courts. I take that to be an indication that as judicial colleagues, there is far more that unites us as judges than differences of opinion from time to time on some aspects of the law, procedural or substantive, recognising that differences can be healthy. Each of the Chief Justice, Dr. Higgins and Miss Ball, has sketched in words a very favourable portrait of me as a judge. I thank each of them for their very generous remarks. To the extent that reference has been made to some of my distinguishing characteristics or traits, I readily acknowledge the accuracy of their observations. For my part, it's been a privilege to have served as a judge of this court and the Court of Appeal for the past 12 years. Throughout that period, I've remained conscious of the responsibility which has been entrusted to me, the judicial oaths I gave, and the effect of my decisions on litigants and affected parties in both civil and criminal matters. At my swearing-in ceremony 12 years ago, I acknowledged the people who had been particularly influential in my education, training and development as a lawyer. That included my parents, who instilled in me the high value of education and learning and the importance of service to others. I adhere to what I said then. Both my parents have since passed away since my early days on the bench. I was particularly close to my father as we shared many interests. My father was a thoughtful and pragmatic public servant from a generation who gave frank and fearless advice to ministers of the Crown. Naturally, he also gave me plenty of advice over the years. When I came to the court, he took an interest in the cases on which I sat and would often gently ask whether I had handed down judgment in a case I'd mentioned a few months earlier. I would attempt to explain the reason for any delay. My mother, on the other hand, took a different approach. I need to explain at this point that she was a very intelligent woman who had achieved far better results than my father in her intermediate exams, but her family circumstances necessitated that she commence work rather than continue school to matriculation. She would often ask me why I needed to work on Sundays. She found my explanation of the laborious task of judgment writing unconvincing. The members of my immediate family who you heard of are here today. Susie, our 3 adult children, their respective spouses and children. We're proud of the lives they've each have made. Tom with Catherine in Orange, Kate and Anthony, and Sarah Maguire, who all live locally. We're very proud of our 3 grandsons, Charles, George and Jack, who are here today to celebrate this occasion with Grandad. Also present, as you've heard, from my siblings are my sister Catherine and brother Justin. Given the very flattering speeches you've already heard, the rule against repetition is appropriate in reference to my legal career prior to coming to the court. However, I should acknowledge the training I received as a solicitor and the time I spent as a litigation partner at Freehills during the fast-paced 1980s was invaluable. That was followed at the bar by the generous mentoring I received from Jeff Lindsay and James Alsop, and the experience I gained from working with a variety of experienced senior counsel, instructed by a very wide range of very good solicitors. The focus of my remarks today, which I intend to be brief, is to acknowledge and thank those people who have particularly assisted me in my role as a judge. As many are aware, the work in the Court of Appeal and the Court of Criminal Appeal is of enormous breadth and can be daunting at times. I greatly benefited from the guidance of experienced judges of both courts in substantive areas of law that were new to me, as well as in areas of law within my assumed expertise. By a process of immersion in the conduct of hearings, I gained an appreciation of the importance of having a curious mind. I'm grateful for the support and friendship of my fellow judges on the Court of Appeal and in the divisions where I sat from time to time. It's been a pleasure to work with in such a collegiate environment with a diverse group of very talented judges. The collegiate environment extends to the support staff, the associate and tipstaves to whom I'll refer shortly. I could not have been prouder than being a member of this court. I'm also grateful for the patience and tolerance of those who have appeared before me. Of course, in our adversarial system, some of the questions asked by the judge testing counsel's argument may seem at times like an interrogation, but it is important that counsel retain the confidence to engage in the process, which assists in the distillation of the legal argument and correcting any misconceptions of the judge. In my time on the bench, it has been good to observe that we have a vibrant bar which works well as part of our legal system. It's appropriate to acknowledge the good fortune that I and also my brother Justin have had as first lawyers in our family, who descended from the Gleesons of Silvermines, County Tipperary, and arrived in the 1850s. In large part, that comes down to the example that was set by our father, and in turn his father, the genes we inherited, and the educational opportunities we were given. Brief reference should be made to some matters of family history, a topic that I did not address during my swearing-in ceremony. The early Gleesons tried farming at Freeman's Reach and later Stony Creek near Mudgee. They were not very successful. They had great difficulty coping with the combination of drought and floods. Many returned to the city. My grandfather, Tom Gleeson, moved to Sydney from the country to train as a bush teacher. Despite his Irish heritage, he was first and foremost a proud Australian. After his return from the war in 1919, having served in the army in northern France and Belgium, he resumed teaching in various positions and schools for over 40 years. He was very active in the local St Vincent de Paul at All Hallows Five Dock over the same period. I recall my father affectionately addressing my grandfather as simply boss, reflecting his standing as headmaster of several schools, including Five Dock Public and Woolwich Public. My grandparents made sacrifices to enable my father to attend high school at St Patrick's College, Strathfield, which my grandfather assessed provided the best chance of my father obtaining a university bursary. That assessment proved correct. My parents, in turn, made similar sacrifices that permitted all 5 children to receive a good educational opportunity. Turning back to matters of the court, I've worked under 2 Chief Justices, Chief Justice Bathurst and Chief Justice Bell. Each has made a significant contribution to the leadership and administration of the court, often in difficult, trying circumstances. That included maintaining the operation of the court during the COVID pandemic. Each Chief Justice had their own particular style, including their approach to the pastoral care of judges, which is essential because the burden of the role is not readily apparent to those not in the role. The position of Chief Justice also presents many challenging tasks, including explaining and defending in the wider community the rule of law, what in fact is meant by that expression, and its importance for the maintenance of our democratic values. The court has been fortunate to have 2 very good leaders in recent times that have addressed that challenge. Turning to the Court of Appeal, I've worked under 3 presidents, Beasley, Bell and Ward. Each of Margaret Beasley, now Governor of New South Wales, and Julie Ward, the current President of the Court of Appeal, have been exceptional trailblazers for female lawyers in this state and Australia. They have also been great colleagues and good friends. Of course, in between, there was President Bell, who doesn't require any further mention. Lest he think incorrectly that I have become a sycophant. It's sufficient to say that I greatly enjoyed working with him and also regard him as a good friend. When I started the court, Jane Miller, who had been my secretary at the bar, was my associate. She retired in 2015. My current associate, Jane Gray, took over in 2016. Jane has provided me with tremendous support and assistance over the past 9.5 years. On occasion, the pressure associated with the gruelling process of editing draft judgments has been intense. I thank each of them for persevering with me. The role of the judge is assisted by young lawyers referred to as tipstaves, a quaint English word for a law clerk or administrative assistant. I've had 12 tipstaves. I won't mention each by name. I've encouraged each of them to learn as much as possible about the practice of the law during their time at the court so that they can make informed choices as to their future career. Each has chosen well, and they are now engaged in a variety of legal careers. Some have or are still working overseas. Some have undertaken further study, whilst others are at law firms, the bar, or in government. I thank each of them for their assistance, good humour and patience in proofing draft after draft of judgments. There are others associated with the court who I'd like to thank and acknowledge. First, the smooth running of the court has been ably assisted by Rebel Kenner, the Executive Director and Principal Registrar, and her predecessor, Chris Deeth. and the support the judges receive from the registrars of the court who deal at the coalface with the many aspects of court proceedings. Second, I thank Jerry Risenhook, the Registrar of the Court of Appeal until September 2023, and his successors. Jerry provided sound advice, including on the many traps for inexperienced judges in the Monday morning referrals list. I also thank the Court of Appeal's Chief Clerk, Val Otakovska, who has kept on top of all administrative matters in the court. Third, I thank the dedicated librarians who provided much assistance in obtaining obscure materials, the small group of department staff who assist the court to function on a daily basis, and the IT team that has responded to my frequent requests for assistance with a laptop that on occasions has tested my patience. Finally, I also thank Edwina Chapman and Gordana Hosman for their work in organising this farewell and the morning tea which follows. Most importantly, I acknowledge the continuing love and support of Susie, who has kept me grounded throughout my career, including as a judge. Although not a lawyer, Susie well understands the critical integers of a slip and fall case, specifically the need for the operator of a supermarket to take reasonable precautions to avoid the risk of harm, as well as the significance of the defence of contributing negligence. Let me explain. The context of two judgments of mine on the Court of Appeal, which received some notoriety in the daily press and from legal commentators, being the stray grape case and the mango fandango case. Both were slip and fall cases involving an unfortunate injured plaintiff who fell on a grape or a mango slice that had dropped on the floor of a supermarket. Shortly after I wrote the judgment about the stray grape, Susie herself slipped and fell on a stray grape at a local IGA. But importantly, that was in circumstances where she had noticed the grape drop from her own basket whilst in the queue at the checkout, but had inadvertently overlooked the risk of harm to which she had contributed. The IGA staff rushed to her assistance, obviously worried about a lawsuit. Susie quickly recovered. The money recently spent on 2 new titanium knee replacements was well spent. She assured the IGA staff that she was fine, and the only thing she had lost was her dignity. No claim was ever made. Susie has endured too many Sundays whilst I have toiled away in chambers both when at the bar and as a judge. That has now ended and will no longer be part of my life hereafter, whatever it brings. We are both looking forward to spending more time together pursuing various interests, perhaps some foreign language courses for me. We're also looking forward to spending more time with our adult children and grandchildren. In conclusion, thank you again for your attendance today. I'm truly humbled that you have taken the time from your busy lives to do so. I wish you well.
All stand. This honourable court is now adjourned.